So guys, we have done with some 180 MCQs relating to Indian Contract Act. Let's go inside and see what is the remaining things that we have. If time is the essence of contract and the promiser fails to perform the contract by the specified time, then the contract becomes unenforceable. It becomes void. They are fixing a limit. Like for example, within 3 months, this contract should get completed. Will we be able to complete this within that time? If it is not performed within that time, then it becomes unenforceable. Next point. In case of death of a joint promisor, the promisee can enforce the contract against the survivor of the joint promisors. For example, one fellow is not there. The other person can perform the contract against the survivor who is already there. Along with them, they will be able to manage this and complete this, and all becomes a very normal way of covering things under Indian contract, not a special thing to be covered. When the performance of the promise by one party depends on the prior performance of the promise by another party, such reciprocal promise falls under the category of conditional and dependent. Very simple. Now, the first part of the job should be completed by A. Based on the completion of A only, B should complete the remaining job. Don't you think it becomes conditional and dependent? Yes, that's what they are saying. Again, very normal point. When an inferior right accruing to a party in a contract merges with the superior right accruing to the same party, the contract conferring the inferior right is discharged. When you have a small activity and when you have a bigger activity, the moment when you connect with them in the bigger activity, the smaller activity should get completed, should get discharged. Automatically, it will get discharged. Again, a very normal point. In contract of sale of movable properties, time is the essence of contract. Don't you think so? So short time means 2 months time, 5 months time, like that. Time is the essence of the contract. Are we clear? Next, let's go inside to an example. W, a singer enters into a contract with M, the manager of the theater, to sing at his theater for 2 nights in every week during the next 2 months, and M engages to pay her 5 lakhs for each night performance. On the 7th night, W willfully absents herself from the theater. Now, what will happen to the contract? Intentionally she does. So M is at liberty to put an end to the contract because M only engages her to be continuing. So this is again a very simple point. Now, this and all normal parlance, if you see itself, you will be able to understand. Only when it is jargons or law related terms or anything relating to that, that alone has to be taken care. Which of the following contract is not discharged by frustration? Frustration means what? Somehow it has to happen. Commercial impossibility. The performance itself is impossible. There will be nothing called frustration because you cannot help. It is not possible at all. So commercial impossibility. Now I will mark this in green color for a simple reason. It is quite tricky for the first time. Novation requires mutual agreement. Novation means what? Substitution. We have already told this. So this also I will mark it in green color. Commercial impossibility is void. We already know this. This is not a big point to remember. Next, acceptance of consideration lesser than that of the agreed is known as remission. Now, they wanted to keep for some 5,000 rupees. Now, but it is actually accepted only for 3,000 means you will remit the remaining and then proceed the further based on the requirement remission. So this all of the above, we are not considering this as a point. So not a big deal to remember. Next, impossibility existing even before or subsequent to the formation of the contract is called supervening impossibility. Supervening impossibility means no chance that it can happen and subsequent to the formation. So the word keyword here is subsequent. And it is called supervening and subsequent impossibility. Next, reciprocal promises are done by both the parties of the contract. This and all is very normal. Next, A promises to paint a picture for B by a certain date for a certain amount. But A dies. What will happen? Agreement will lapse. That's a very simple point. One fellow died. So what will happen? agreement will lapse. Contractual impossibilities, otherwise called supervening impossibilities. Maybe I'll put this in green color. They may quickly ask you this in the examination. X paid to Y 7 lakh for purchase of flat. Y promised to give the possession of flat after 1 year. Is that already executed? No, it is executory. It is yet to happen. So this is a normal term. Completed means executed. Yet to be completed means executory. Next one. The person by which one person succeeds the right, interest, benefits, and obligations of another. Succeeds, openly they have told. So the keyword is succeeds, and the answer is succession. Next point. Brown promises to sell his house to Crown for some rupees. Later on, both of them agreed not to execute the deal. They are cancelling it, which is called a recession. Don't confuse recession with remission. Remission is remitting the amount. Recession means cancelling. So what I will write here? I will write here cancellation. Are you clear? Next, A agrees to pay 10,000 to B after 2 years. Do B dies, unenforceable. We already told this, correct? The agreement lapses. Supervening impossibility will lead to frustration, normal point. When there is a change in the terms of contract, what of a contract takes place when all or some of the terms are cancelled? You will alter the whole contract. So novation, rescission, alteration, remission has to be taken care. I will again repeat. There are 4 important terms to be remembered: novation, rescission, alteration, remission. So write this a separate list. Go and find out what and where and all I would have spoken, and you can accordingly make it. So I will say 4 important terms of contract. What are they? Shall we write? Novation, rescission, alteration, and remission. There are 4 things. Now, this we are already told for novation, rescission, alteration. Remission also we told. Rescission we will see. X contracts to Y to import, to sell the imported car. Later on, both the parties decide not to, means they will cancel. Next, A holds a house under lease agreement. Subsequently, he buys the house and becomes the owner. Now, what happens? What is being leased is now merged as his own person, own property. Contract between promiser and promisee becomes impossible, means automatically it becomes void. So impossible is the keyword to be remembered. You don't need to even see the full thing. You will understand it very easily. Which one of the following is relevant in normal circumstances in determining the amount of damages? Very important point. So I'm marking this in green color. How they will determine the difference between market price and the contract price will be determined based on that. Are we clear? Yes, determining the amount of damages, how you will determine difference between market price and contract price. This is coming under a concept called damages and types of damages. So that's one of the most important thing. A party who does not suffer any loss, but basically base damage, normal damage will be called nominal damage. Why I'm marking all this in green? All the damages will come one after another. Specific performance may be ordered by the course, when the damages are not an adequate remedy. When damages are not possible, perform. So go and enter into the contract. If that fellow is not able to perform, he will say, do the activity. That's all. Now, let's take for an example. You go directly to a restaurant. You don't have money. Okay, they will not force you to give the money, but they will make you work there. As simple as that. So performance will become if the damages are not an adequate remedy. If you don't have enough money, they'll ask you to go and work there. That's a very simple point. So that's what they will do here. Next, damages which an aggrieved party claims beside general damages for any loss he has suffered owing to special circumstances is called what damage? Special damages. Special circumstance. What's the answer? Special damages. Next, Dash damages are measured on the basis of extent of shock to the sentiment. So mind level, body level is not there. Mind level, if there is anything, they will say it is called vindictive damages. Please remember and write this separately. Like how I asked you to prepare novation, rescission, alteration, remission, like the list of damages. It will also be there in your material that's provided. What I am doing is I am doing opposite. Instead of saying the type of damages, I am telling you, explain me one after another so that it makes our job very easy. In case of anticipatory breach, where the promisee elects to keep the contract alive, if during the time of contract remains open, it becomes void. So automatically it becomes void. This and all is a normal point to be remembered. Yes. Now let's go to the next level. P contracts with Q to deliver the possession of a house under construction within a period of 6 months, failing which he would pay the monthly rented. Now, depending on the usage when you pay a damage, it is called liquidated damages. Are you clear? So if you don't do a particular activity and if it is halfway, then they will use a word called liquidated damages. What is the next one? P contracts with Q to deliver the possession of the house. Yes, that's what we have covered. Next, N chartered M's ship and agreed to lead it with the cargo in Orissa within 50 days. Yeah, so N chartered M's ship and agreed. N was unable to supply the cargo, but M continued to demand it. Meanwhile, war broke out, rendering the performance impossible. In such case, it is supervening impossibility. Nobody can claim anything for a damage. It is discharge. Why I am marking it in green? Because you should not say now they can accordingly sue for it. No, supervening impossibility, contract will automatically get discharged. In which of the following cases a claim is not enforceable on the ground of quantum merit? Quantum merit means based on the damages that is there, they are telling. A undertakes to build a house for B for rupees 25,000, but after having done half the work, he abandons the contract. B afterwards completes the house. This is not enforceable. Now, the point to be remembered is this is half-baked question. So we can accordingly go to the next one. G, a film star, agreed to act exclusively for Y for 1 year. During there, she contracted to act for some other. Do you think it is going to be there? No. It can be restrained. Y can restrain G by an injection. He can get a court order. He can get a court order and stop her. That is that. Yes. Next, E contracts to marry F. Before the agreed date of marriage, E marries K. Here, F is entitled for what? Anticipatory breach. Even before the event happened, it is going to be there. Now, for example, today I am coming to the class and saying I am not performing the contract. I am not taking class. I am doing it on the day, actual breach. 1 week before itself, I told I am not going to take the class on Tuesday or Wednesday. What is this? Anticipatory breach. That means even before the event happened itself, I told. So what are the two types of breaches? You can remember. I can also write here. There are two types of breach: actual and anticipatory breach. Are we clear? Yes, so that is going to be that. Next, quantum merit means what? As much as is earned. That's what I told. In the way it is getting completed, this also is going to be in green color. Why? Quantum merit is a jargon term. As much as is earned. Now, the damages which are not natural and direct, some damages you pay, or the recoverable damage, not recoverable damages are also called remote damages. Are we clear? I'm marking all this in green color. You know why. Dash damages is for you to establish a right of decree. This and all is only normal damages. You don't have a separate damages for it. If a part or a party refuses to perform its part of the promise before the due date. I told you before the due date means what? Anticipatory breach. Anything special when the plaintiff has proved that there has been a breach of contract but he has not suffered any damage. automatically he can get a special damage also. This is more different. You can also get a normal damage. You can also get a special damage depending on the situation. Unusual circumstances, it is not recoverable. Normal point. Breach of marry, very important. I'm going to mark this. When you said you will marry, but you have not done, exemplary damages will be provided. A said that I will marry C, but he did not marry C, means it is they should pay exemplary damages. The basis of quasi-contractual relation is, it is not a contract, it looks like a contract. They will say unjust entrenchment will be stopped. It will not be like a what? It will not be like a magic. They will prevent that unjust thing because it is not a contract, but it looks like a contract so that nobody gets disturbed. This is quite an important word to be remembered. The moment when they say quasi-contract, it is for the prevention of unjust enrichment. That means you are stopping something unusual. That's what they are saying. Raining. If it is raining, I'll give you 500. If it is not, you give, means that and all is not allowed. Wagering contract. So I'm making it in yellow color. You don't need to bother. We have already done this. A agrees to pay B a sum of money if a certain ship does not return. The ship is sunk. B can enforce the contract when the ship sinks. This becomes a tricky type of a question. Now, advice B, you cannot actually do this. So what I'm doing is I'm marking it. It depends on the person. It becomes more voidable. You cannot say it's valid. You cannot say it is void. So this is more voidable. For quasi contract, what are the 4 things to be remembered? I'll mark this in the green color. What are the things you need to remember? Claims for necessaries supplied to a person incompetent to contract. Yes, quasi. Responsibility of finder of goods. I find somebody else's goods. They have not entered into the contract with me, but I will give the goods to them. Don't you think so? Yes, I found some purse here. It is not mine. So I am searching one person and I'm going to give. Did me and that person have entered the contract? Did we say that wherever I leave the purse, please come and give it to me? No. It looks like a contract, but it is not a contract because the property is not mine. It should be given to the owner. Responsibility of finder of goods. Reimbursement of money paid due by another. I am getting money on behalf of some other person. Don't you think I'll give it back to them? Yes, we have not signed a contract, but I will give it because it's their money. Obligation of person enjoying the benefit of non-gratuitous act. Anything you will have to pay them for consideration should be given them as a benefit. All the 4 are quasi-contracts. Are we clear? Next, claims for necessaries of life supplied to a lunatic under 68 can be enforced against either his property or estate. We have already told this for minor, you remember. Now they are also talking about for lunatic. Yes, the person who finds the goods belonging to another and takes them into custody. Now, for example, I have a laptop. I am giving it to another person and say, please take care for 3 days. I will come back and get it from you. Who am I? I am called bailer. I am giving it to one person who is taking care of that with the custody. They are called bailee. This agreement is called bailment. So safe custody. So what's the keyword you will have to remember? For the custody to take a same responsibility. Who will take? Bailee will take. Bailee will take care of bailer's goods, which is called bailment. Are we clear? Dash are the contracts implied by law. Implied only, not directly done. It looks like a contract, but it is not. So implied by law. What is the answer? Quasi-contract. Yes, till 2:30 we have completed. Now let's go and see what is going to be there for the remaining concepts on Indian contract.